All right, good evening, everyone. I want to welcome you to this latest installment of our Know Your Rights workshop. My name is Janelle White. I'm with the Temp Worker Union Alliance Project, a project that is housed in Warehouse Workers for Justice. Today, I am joined by my colleague, Bobby Firestone, an organizer with Warehouse Workers for Justice, and attorney Ada Sandoval of the Raise the Floor Alliance legal team. Before we get started with the workshop, I want to give you guys a little bit of background about all of our organizations. So I will start by telling you a little bit about TWUAP. So TWUAP, the Temp Worker Union Alliance Project, exists to bridge the gap between temp workers and unions. We believe that temp workers should have an opportunity for sustainable jobs, permanent employment. They should not be stuck in a cycle of perma-temping, and they should be able to get paid the same wages and have the same benefits to do the same work as direct hires. So we partner with unions to try and introduce temp workers to organized labor. Bobby, if you could tell our viewers about Warehouse Workers for Justice.
Hey, how you going, everyone? I'm Bobby Price. I'm an organizer with the Warehouse Workers for Justice. The Warehouse Workers for Justice is a worker center fighting for good living wage jobs in Illinois' warehouse and transportation industry. We organize workers and educate workers on their rights in the workplace and help them enforce their rights to fight for public and private policies that promote better conditions in the workplace.
Thank you, Bobby. And now, Ada, if you could tell us a little bit about Raise the Floor Alliance before you go into your presentation.
Yeah, so hi everyone, my name is Ada Sandoval. I'm a staff attorney at Raise the Floor Alliance. And Raise the Floor Alliance is a coalition of worker centers in the Chicagoland area. So worker centers such as Warehouse Workers for Justice, and we're here to help protect workers' rights and promote workers' rights. And thank you for having me.
Thank you so much. We really appreciate you being here. We're so grateful for these partnerships with organizations and worker centers like Raise the Floor Alliance, and of course, our partners at Warehouse Workers for Justice. So we want to invite those of you that are able to tune in live to like, comment, and share this broadcast. If you have any questions for Attorney Sandoval, please leave them in the comments and we'll make sure that she gets them while we're live. So without further ado, I'm going to hand it over to you, Ada. Take it away.
Thanks, Janelle. So I have a presentation prepared, so I'm going to share my screen. Hold on. Oh, wait. Oh.
Hey, everyone, while they're working on getting things together, I want to remind you guys to please share the workshop, because it's the only way we can get it out. We got to share this workshop so it can get in front of as many people as possible, because that's the way we reach people. When we reach people, we teach people. So please remember to share the workshop, everyone.
All right, there we go. We can see your screen now.
Perfect.
Thank you.
All right.
Thanks, Bobby.
Hold on. Oh my gosh, I am blanking on the whole, actually watching it. Sorry. Where are you? There we go. All right. So first, just as a general disclaimer, I'm just doing providing general information for workers. This is not considered legal advice. So questions are welcome throughout the presentation. Like Janelle said, you can comment on the post, and I will find out what the questions are through Janelle and Bobby. That way we can make it kind of more of a conversation instead of just like me lecturing, but either way works. And also, just if your questions get to be like a little bit too specific, it might be that I can't answer because it would be going more into legal advice. So if there are some questions that are like too specific, that would be where it's better for you to go ahead and talk to Janelle or Bobby or an organizer from the Warehouse Workers for Justice. And then they might direct you to me or to another attorney for more assistance if it's one of those situations where you need more assistance and actual legal advice from an attorney. So we can just jump into the general information that I have to share. And this is going to be focusing on workplace rights and how they relate to COVID. So we're going to start with the right to organize. And we like to talk about the right to organize, especially when it relates to like COVID and just in general working conditions. Because that is where workers, when you unite, you have more power to like ask for these changes in the workplace. And the law does protect your right to organize. So under Section 7 of the National Labor Relations Act, what the law does is it protects the rights of employees to engage in concerted activity for the purposes of mutual aid and protection. So that can include that includes 2 or more workers taking some action at work, like presenting a petition, or one worker calling on other workers to act. This would be like the call to action. And in regards to like COVID, so if the workplace that you're at isn't taking like enough precautions, while it might not rise to a level of like safety for OSHA, and we'll talk a little bit more about OSHA later, but it's still something that's concerning and a lot of workers are concerned about it. You can band together and make some demands to the management so that they can hopefully work on making those changes and making the workplace safer. And for the concerted activity to be protected under the law, it does have to involve workers discussing work matters. And this would apply to most employees of private employers, and that would include temporary staffing agency workers. There are some exceptions, and that would include supervisors, management, domestic workers, and independent contractors. But it is good to note that like with supervisors and management, sometimes the employer kind of just gives these like empty titles to supervisors and management, but they're not actually taking on those roles. So there may be like rare situations where supervisor and management, because they're not really under that category, could still be protected. But generally they're part of the exception and are not protected under the protections of Section 7 of the National Labor Relations Act. So say that you have engaged in concerted activity, you are part of presenting a petition, or you signed a petition and then the employer found out and they're trying to fire you, or they're like changing your hours drastically, or just your working conditions somehow. Then you would have a charge that you can file with the National Labor Relations Board. And in order to file a charge, you have to file it with like the local office, the National Labor Relations Board regional directors. And the charge has to be filed within 6 months of the violation. So that does go by pretty quick. So it's just good to note that if you've been fired or like something happened at work because you were engaged in concerted activity and you were organizing and you think they're retaliating against you, then you do have those 6 months to file a charge. And the charge can be filed against either party that interferes with a worker's Section 7 rights. So if you were working at a client company and the client company found out that you were part of like the petition, or you handed in the petition and afterwards they fired you, or they told the agency they didn't want you to go back to the client company, then you would have like a claim either against the agency or the client company, or both. You can file against both as well. And some examples.
I'm sorry, if I could jump in here for a second. So, and thank you so much for these slides. As always, they're so packed with useful information that workers might need. But I just wanted to highlight that if a worker feels like, and you can correct me if I'm wrong, please do. If a worker feels like their rights have been violated and they want to file a charge with the NLRB, they can do that on their own. They don't necessarily need an attorney to do that for them.
Yeah, you can do that on your own. You can call their office and they'll have people there that are that will be able to like assist you in that process. So you don't need attorney representation for that. You're correct.
Great, thank you so much.
And then a couple of examples of protected concerted activity include, but it's not just limited to this, discussions of working conditions, circulating petitions, or discussing joining a union or striking. And just a note on strikes and work stoppages. If your demands to management are strictly limited to economic demands, like if all the workers are asking for is a raise, then the employers could permanently replace the striking workers. So if demands are being made to an employer, it's best to include like all other working conditions that you would want to see changed, so that it's not just strictly asking for a change in pay. And usually places that are doing like are paying like minimal or just a minimum wage usually have like other issues going on. So it should be, you should be able to add more than just the demand for a raise. You should also be able to address working conditions, or like maybe even like if the place that you're working at doesn't have a set procedure for firing, that could be an example of like a change you want to see in the workplace, that you want to see a set firing policy, or make it so that there have to be warnings given out, things like that. So different demands in addition to like the raise, not just a raise. So before we jump into OSHA, I did want to see if there are any questions on Facebook or from you guys.
No, we don't have any questions on Facebook at this time, but it is a good time to remind people, those of you who are able to watch this while we're live, to please like, comment, and share this broadcast so that we can get it in front of as many people as possible. I guess I do have a question that's not necessarily related to organized. Well, I guess it could be, because, well, TWUAP wants to see unions organize temp workers. So the question that one of my coworkers asked earlier today, let me pull that up. So a lot of union contracts, when they organize a workplace, they have language in the contractual agreement, which is called the bargaining agreement, that states or stipulates that temp workers should not be in a temporary employment position for longer than a 90-day period. So at which time, if they successfully, complete the 90-day period as a temp worker, then they should be eligible to apply for a direct hire position, which means a permanent employment position, because temp means temporary. There's really no guarantee of employment. For those who are watching who may not be familiar with the temporary staffing industry. So the question is that a law, or is that just contract language that unions have been using? And then the second question was, are companies required to post a direct hire position and make it available, or accept that post accessible to temp workers?
Yeah, so from my understanding, that is more to the first part of your question, the language of like the 90-day period before they can become permanent workers. That is that sounds more like from a bargaining agreement. Yes, the law itself, from my understanding, it doesn't give that route for temporary workers to become permanent placements. And the protections that are available under the law, they haven't been like tested out in courts yet, so they're not as strong, unfortunately. Right now, it's just like the bare language of the statutes. And what the bare language of like the law does say is that the client company has to let the agency know that there are available positions for the temp workers to be placed on in. So that's where like the language unfortunately isn't explicitly like the client company has to let the workers know. It has to let the agency know, and then the agency is supposed to let the workers know. Yeah.
Okay, great. Thank you so much for answering both of those questions.
Yeah, no problem. All right, so we can jump into OSHA, the Occupational Safety and Health Act. And with OSHA, it's just if there are like dangerous conditions in your workplace, or you've seen that the employer, your management, they're not following like safety regulations, OSHA is supposed to enforce those safety regulations. So if there's any issues with that, that's who you report any violations to, and then they will investigate the workplace. And usually like just starting an investigation might cause the employer to make those corrections. And with COVID, it's a little bit more difficult to say like how well they'll react, or like how much they'll do in investigating like the COVID issues. Under the past administration, they weren't really doing much with COVID violations, but as under this new administration, I'm not entirely sure how they're prioritizing those complaints. But it's still like a venue. It's still a way that you can report it to OSHA if there are issues that you're seeing in the workplace, especially when it comes to like it's getting people sick in the workplace, you know. And if the employer finds out that you've reported it to OSHA and they take any action against you, OSHA also protects against retaliation, but it does provide only like a small window for you to file. So this one's pretty quick. It's 30 days to be able to file. So there's really no like, don't wait around if you're in the situation where you reported it to OSHA and then you find that you've gotten fired or they've like really cut your hours or something like that, because you'll be under that 30-day time limit. All right, so I know that was pretty short for OSHA, but if any questions come up, just let me know. And we can go on to the Chicago COVID Anti-Retaliation Ordinance. So this is explicitly relating to COVID. And what it is that Chicago has an ordinance that protects employees from employers retaliating against them if they are following an order regarding health, and especially relating to COVID-19. So like if your doctor has told you to stay home because you have COVID-19 or because you've been exposed to somebody with COVID-19 and you're trying to minimize the transmission, or you're taking care of family members who have become sick with COVID, then and the employer like retaliates against you, like they fire you for this. In Chicago, the ordinance would protect you, and you can file a violation with the Office of Labor Standards. And then also like civil actions like in court would be available. All right, and then with earned sick leave, and this is in Chicago and in some Cook County municipalities. Some Cook County municipalities have opted in and some have opted out, and that list is can change. So I do have a list at the bottom of this slide, but it might not be current in like next month. So what you would need to do is find out from that municipality, call like the village clerk and find out if they're opted in or out. If it does come to a situation where you're trying to figure out if you have earned sick leave. But in Chicago, you do have earned sick leave. And what that means is the workers accrue an hour of paid sick leave for every 40 hours they work. and they're able to take their sick leave after 6 months of working at that with that employer. And you are able to carry over some of that time and also use that sick leave for your own illness or the illness of a close family member. The employer is also not allowed to ask you for doctor's notes if you're sick for 3 days or less. If it's more than 3 days, that's when they can ask for doctor's notes. But less than that, and they should not be requiring a doctor's note for you to get back into working and back to your job.
I have a question that came up from my worker about earned sick leave. At the
Yeah.
completion of employment for like, if you were fired, doesn't your earned sick time or like PTO have to be paid out in your final paycheck? Is that correct?
Not the sick leave. So the vacation should be paid out. That's usually if the employer has a vacation policy, then that pays it out and everything, then the employer has to stick to like that policy. Unfortunately, there isn't really a vacation law in Illinois, but there is a law that like if you had that policy, it's kind of like a contract. So they have to hold up their end of the contract. And if that contract was they pay out their employees their vacation time, then that's what they're owed at the firing. Yeah, once they're fired. So that's where it kind of like, if you can show that the employer had a vacation policy and they didn't pay you out, that's when you would have a claim that you can file with, you could even file that with the Illinois Department of Labor.
Ada, I had a question about the previous slide. So several workers that several workers that we've encountered during our outreach and hand billing have been telling us stories about them feeling as though they may have been retaliated against, wrongfully terminated or disciplined because either they themselves had COVID-19 or they had to, they were entrusted with the care of a loved one, like a child or an elderly relative who ended up contracting the COVID-19 virus, and then their employer, didn't honor their request for paid time off. So these were direct hires. Obviously, that'd be a little bit more tricky with temp workers because they often don't have those same benefits. But if a direct hire was not granted their PTO as it relates to COVID-19, how is that being enforced? Like what agency should be alerted that a work site isn't honoring that?
Yeah, they can. So this is where if it's specific to Chicago, because if it's outside of Chicago, that's where there really isn't enforcement of it. But in Chicago, because Chicago passed the anti-retaliation ordinance, the Chicago Office of Labor Standards, the Office of Labor Standards, is the one that is enforcing it in Chicago. And for that, it's relatively easy. Like you can call 311 and they should be able to connect you to the Office of Labor Standards. But the Office of Labor Standards also has their own website, so you can find them online as well. But they're the ones who are processing any of those claims, any of those violations that employers aren't following the law.
Thank you for answering that question. And if there are any workers out there watching or viewing this after the fact and you feel that that is applicable to you, we invite you to reach out to us. Our websites are www.4j.org and TWUAP.org. We're happy to make referrals to our friends at Raise the Floor Alliance legal team and other legal services that we've partnered with to try and sort of bridge that gap and make these resources accessible to workers who wouldn't otherwise know about them. So thank you for that, Ada.
Yeah, no problem. Thanks for the questions. All right. So With the earned sick leave, like I mentioned, some municipalities have opted out. So like the list that I have here, Barrington Hills, Berwyn, Cicero, Countryside, Deerfield, Dalton, Evanston, Glencoe, Glenview, Kenilworth, Lincolnwood, McCook, Northbrook, Oak Park, Oak Brook, Phoenix, Skokie, University Park, Western Springs, Wilmette, and Winnetka. Last we updated the list, they had opted in, but given like the new year and the ability for these municipalities to opt in and out, it's possible that it wouldn't be the same in January 2022. So it's best just to double check if it is that you have questions about it. And there are COVID-19 vaccination rates for employees, and if your employer is making you get vaccinated, then you should be compensated for going to go get the dose. And especially if it's during your shift, sorry, if your appointment is during your shift, not if it's outside those hours, but if your employer is requiring you to be vaccinated and your appointment is during your shift, that still should be compensated. And it's up to 4 hours per dose. And that should apply to the booster, but I'm not 100% on that. But especially if the employer is requiring it. And then if your employer is not requiring you to be vaccinated, but you still go and get vaccinated, and you have accrued sick leave, you can use that for the hours that you go and get the vaccine. And yeah, the employer cannot require the employees to get vaccinated outside of work hours. So they can't say like, hey, we need you to be vaccinated, but you have to make your appointments after 5 o'clock or before noon. If you like before your shift, they can't require that. And so, as I mentioned before, if there are any sick leave violations or any retaliation violations, especially with the Chicago anti-retaliation for COVID-19, then you can call 311 and they'll put you in touch with the Chicago Office of Labor Standards. If it's a violation of the Cook County Ordinance, so if it's like your earned sick leave and you're in a village in a municipality that does have sick leave, you can call the Cook County Commission on Human Rights. And there's always the other options of you can talk to a worker center and see if this is something that they can help you organize in the workplace, or they can refer you to an attorney. And then also the possibility of filing a lawsuit in state court or even in federal court if you can combine it with violations of federal law on top of the Cook County or Chicago violations. All right.
Okay, great. Well, thank you so much, Ada, for that presentation. As always, we're so grateful to have you be here with us and to provide this information and resources to the workers that we serve at WWJ and at TWUAP. Well, I don't think we have any viewer questions currently, so I'd actually like to take a couple of minutes and talk about some of the other work that we're doing. In addition to keeping these Know Your Rights workshop series going, we are also working with the Cook County Department of Public Health and the Center for Disease Control to boost COVID-19 awareness, prevention, testing, and vaccine, and now booster accessibility. So CCDPH actually has some vaccine clinics coming up next weekend, December 9th through the 11th. They typically are servicing Cook County suburban areas. So if you'd like more information about those sites and the times that the vaccines will be available to the public, we invite you to visit our website. We actually have that information posted. We try to keep up with it as best as possible. And you can also visit the Cook County Department of Public Health website or call them for more information. If you need a ride to get a vaccine, those are available as well. So again, feel free to reach out to Warehouse Workers for Justice or TWUAP for more information. And I believe there's another vaccine clinic happening in Fort Heights on Saturday, I'm sorry, this date is wrong. I think that one happened already. So just the ones that I mentioned previously with the Cook County Department of Public Health happening the 9th through the 11th. So again, I want to thank you, Ada, so much for being here with us today and continuing the partnership to fulfill these Know Your Rights workshop series. We probably won't have another one until January, but we will be back. So those of you who have been watching and leaving us questions as we continue with these series, we appreciate that. Even if you're catching this after it was live, still, leave a comment. One of us will try and get back to you as soon as possible, or someone on staff will see it and get back to you as soon as possible. And yeah, thank you for tuning in. Thank you for watching. Thank you for sharing this. And happy holidays to everyone. Stay safe, and we'll see you next time. Thank you.